or I still do not consent. Consent comes from the Declaration of Independence. Their second paragraph down talks about the consent to be governed, and also William Lynch letters talks about when slavery ended or commerce was created. Well,
Declaration of Independence isn't law. That's not law. I wouldn't quote that anymore. All right. Miss Referee. All right, we have 3 files here. I have 22 civil infractions, 1 misdemeanor case. Misdemeanor file is 25F00373ON. People in the city of Burton versus Christopher Allen Renfro, and then the 2 civil infractions, 25F00141OI and 25F00394OI. People of the city of Burton versus Christopher Allen Renfro. And Attorney O'Dell.
Good afternoon, Your Honor. This is the time set for a pre-trial and possible motion hearing. I received no motions, so I don't anticipate there being any this time. And we just asking if we continue to the jury trial as my associate has indicated that Mr. Renfro is not and is not inclined to accept any sort of offer.
All right, thank you for that. And then Mr. Renfro, can you go ahead and state your name for the record?
my name is Christopher Allen Renfro. Today I am demanding vacate of these matters, for I still do not consent. The jury trial is not a grand jury, so in violation of the provisions of the Constitution of the United States of America. Also, the traffic tickets were not criminal, which this jurisdiction is for criminal, so I might force vacated also. No, there was no proof nor burden that the testimony of the cop was true. And there was also no evidence. I still have not gotten a discovery, which means don't sound like plaintiff is ready to move forward either. So that's my statement. Man, the court to vacate these matters or restore them wholly.
All right, thank you. So most of what you stated is incorrect, and I'm denying your request to vacate or dismiss. If proper term would be dismissed, but denying that request. One thing that you did mention, though, that I do want to talk about is the discovery issue. And so, is there any discovery that Mr. Information does not have?
There is a police report in the criminal matter and then the tickets that he received.
Has that been provided?
I have no way to provide that to Mr. Renfro. He offered it to them previously and did not take that.
How would you like that to be given to you, sir?
Well, the 24th was the cutoff, so we're past the cutoff, and that means that there's no discovery on either side.
Well, what it means is that the rules in this court are set by me, and if you want discovery, don't interrupt each other. If you want discovery, because you just stated you wanted discovery, so if you want discovery, I'm going to make sure it happens. So if you want discovery, how do you want to give it to me?
I know, we're past the cutoff line, now want to vacate.
He doesn't want it. All right, well, if you don't want discovery, that's fine. In regards to work, also I want to mention, not right, but somewhat maybe along the path towards that somewhere. When you say the thing about the civil infractions, so you're right, civil infractions are not criminal matters. They are civil infractions for a reason, because they don't carry any penalty of going to jail or anything like that. And so you are entitled to a jury trial on the civil infractions. You are entitled to a formal hearing. So my plan would be to have the formal hearings either before or after, depending on how it works out, the jury trial on the misdemeanor matter. Attorney Odette, do you have any objections to that?
I have none, thank you.
All right, and Mr. Renfro, I know you don't want to be here, you don't want to do any of this, you don't consent to anything, but nobody here on a criminal case really consents to it. So, is that all right if we do those things at the same time, or would you prefer to come back on different days?
Consent comes from the Declaration of Independence. Their second paragraph down talks about the consent to be governed, and also William Lynch letters talks about when slavery in different colonies was created. What differentiated the two was consent. So maybe we need to go back to our books.
That is a very interesting concept. And again, incorrect. Also, Declaration of Independence isn't law. Declaration of Independence was a declaration that we made to King England about what we wanted to see happen in this country. So that's not law. I wouldn't hold that anymore. I wouldn't hold
Reasons why I went to war with England.
One more time.
Don't
Don't interrupt each other. We're going to keep doing this, and I'm going to keep reminding you of that, because if you try to do it while we're having a jury trial, I'm going to shut it down way faster, because we're not going to do it in front of a jury. All right? So, again, remember, we don't interrupt each other. So let's go back to the question, which was, would you like to do the jury trial and the formals on the civil infractions on the same day, or would you like to do them on different days? That's the only answer I need right now.
Proceed how you feel, because you're already have. So.
Okay, I agree with that. So we will set them for the same day. I think that will be more convenient for everyone involved. And again, we do try to be convenient for people around here. Okay, and so let's set this then for.
I believe it's on the set. We're going to score low. But nobody goes on, he said, I'm not just future. But it was not separate name.
If we set this for August 7th, Mr. Renfro, is that acceptable? I know no date is acceptable to you, but are you free on August 7th?
I'm filming 78.
Okay. All right, you'll get a notice. We won't send you a summons, so we will send you a notice for you.
Only summons a little bit.
Well, if you don't show up, I'm going to issue last word for you. Yes. Be fair warned. August 7th, jury trial, 2025, August 7th. At 8:30 a.m. That will also be the same date for the formal hearings on the civil infractions. And like I said, I'm not real sure which ones we'll do first or last. So I'm thinking we'll probably do the jury trial first, so we get through in an hour here, and then we'll move on to the civil infractions. That way, if we have to come back the next day on the civil infractions, we have to bring the jury back. Last thing before we leave, Attorney O'Day, you mentioned that. Actually, there's two more things I want to talk about before they go. One, you mentioned that today was set for pre-trial and motion, and I do have as well have it that there's no stuff for motions, but I don't have any written motions filed. Did either of you file any written motions?
I did not, Aaron.
Did you? Mr. Renfro?
No, I do not.
No? Okay. All right, so I don't know why that was set over that. I don't even almost the day of that. All right. Well, then that's not an issue. I will also note that right now the jury trial actually has a date for Friday, September 5th.
Yes, that was the beautiful month. This is the date for we're still to have okay. We are 14 days to do this.
Gotcha.
And we just come to me.
All right, so you want to do August 7th or September 5th? There's like either day. It's going to be fine.
All of this, of course, especially.
I say August 7th is good date as any, so we're done. We had it originally set for maybe it was July 25th. We had to move it because there was kind of residency or something. I don't remember what happened on that date. It was something weird. So then we moved it. We'll move it back to August 7th. That way we can get Mr. Renfro in a little bit sooner rather than later. I think those are all the things that I wanted to cover, except one more time, Mr. Renfro, I know we've already talked about this, but it is your intention to represent yourself in this matter, is that true?
Including my intention to present this cause.
Okay. You do not want me to ask the defender's office to appoint you an attorney, is that right? You don't want that, right?
No.
And you do not want to retain an attorney, is that right?
Right, I'm competent, and I will see matters through myself.
All right, you understand, I know we've talked about this before, but you understand that Attorney Odette, the people that work in our office, that are lawyers, have law degrees, they've been through law school, they've been doing this for many years, and according to the people in the legal system, you are gonna place yourself at a significant advantage by representing yourself. Do you understand that?
Disadvantage? Yeah.
A disadvantage. I'm sorry, I didn't say advantage, that's disadvantage.
I see it another way, but
That's fine, that's why people represent themselves, and they think that they can do it, and you seem pretty confident to me, as long as we all respect each other and respect this room, everything will be fine, and you can represent yourself. I don't have a problem with that, but if we start crossing those lines, that's when we're gonna have a problem, okay? All right, I think that's it for today. Thank you.
May I go?
Yes.
Nice.
This case centered on a consent-based argument commonly associated with the sovereign citizen movement, raising the question of whether an individual's refusal to consent to governmental authority created a recognized legal basis for dismissing pending proceedings. The legal question before the court was not whether personal beliefs could be sincerely held, but whether those beliefs identified a valid procedural foundation for the judicial relief requested under the applicable rules of procedure. That distinction shaped the court's evaluation from beginning to end. The position advanced reflected a view that governmental authority depends upon an individual's personal consent, while the court's responsibility extended only to determining whether the claims presented were supported by recognized legal authority. Those responsibilities are fundamentally different. Personal interpretations of historical or constitutional principles may express deeply held convictions, but courts must evaluate requests for relief through established legal standards, rather than individual understandings of governmental legitimacy. The governing legal principles in this matter involved court authority, procedural requirements, and the legal relevance of the arguments presented. The record reflects that the court distinguished between constitutional concepts discussed by the individual and the legal rules governing the pending proceedings. It also demonstrated that requests to dismiss a case require an identifiable legal basis supported by applicable law, not simply disagreement with the existence or authority of the judicial system. Judicial review depends upon legally recognizable claims capable of being evaluated within the procedural framework established by law. More broadly, the record demonstrates an important feature of courtroom decision-making. Legal terminology, historical references, and constitutional language do not independently determine an outcome unless they are connected to the specific legal standards governing the issues before the court. Procedure exists to ensure that every claim is evaluated through consistent rules, allowing meaningful judicial review while preserving fairness for all parties, regardless of the arguments presented. Ultimately, this case illustrates that the legal process is designed to resolve disputes by applying established legal standards to the issues properly before the court, ensuring that outcomes rest on recognized principles of law, rather than the terminology, theories, or labels advanced by the parties.